Very much, Gleb. I think it's clear that our panel includes all the stakeholders in researching the Romanian experience. We have a representative of pre-trial investigation, we have a judge, as well as a representative of the Romanian party, and today we'll be talking about all the aspects of the process in Ukraine and all the aspects of the process in Romania and the lessons we could learn and the best practices we could borrow. Each of you has the desk, the analytical note here. I'm a co-author of the text. In your hands, I will try not to abuse my position of power, but I will do my best to be unbiased as a moderator. So I'd like to give the floor to Alexander Lemonov, the founder of State Watch, who was in charge of writing this document and who will give you an in-detail presentation of the sections and contents of this study. Alexander? Thank you, Yevgen. Thank you, dear panel participants, for making it here to our presentation. I'm hoping that presentation will be shown on time. For 3 years we've been working on saving the anti-corruption reform in Ukraine. We started doing this when the previous government was still in power. We didn't have a clear understanding of who would win during the election, and so 18 months ago we had an approximate understanding of how the previous president's team, as well as their satellite, because the National Anti-Corruption Bureau is not how the new government or the previous government will act in regards to the recently established National Anti-Corruption Bureau and the Specialized Anti-Corruption Prosecutor's Office as a subdivision of the General Prosecutor's Office that presents public prosecution in court and also oversees high-profile cases. We analyzed the Romanian situation, and using the experience that Romania got, we exchanged our experience and we tried to see how we could use this in Ukraine. There will be no linear, direct conclusions here. I cannot say that we found the golden mean. We haven't found the silver bullet that would lead us to trumping over corruption. It's not quite that clear. It's not clear cut. Everything depends on factors that I will talk about a bit later. The key difference between the National Anti-Corruption Directorate, a part of the prosecutor's office in the highest cassation court in Romania, and the National Anti-Corruption Bureau and the Specialized Anti-Corruption Prosecutor's Office, is that the Romanian directorate came with detectives and investigators and prosecutors, and we have two of these bodies. They're separate, and I think that the Ukrainian system is by no means worse than the Romanian counterpart. I've already mentioned that the National Anti-Corruption Bureau is a law enforcement authority. It's a state law enforcement body established on a law from October 14th, 2014. And I can say I have taken part in the selection procedure I've taken part in the competition to occupy my position, and this competition can be called one of the two most transparent and most clear competitions during the last 5 years of Petro Poroshenko's rule. During the competition selection to the High Anti-Corruption Court, and the rest of the competition procedures had dubious levels of transparency, and one could hardly call this selection transparent and honest. The Ukrainian law on prosecution, it was amended in 2014, and we had a procedural code established to oversee the activity of the National Anti-Corruption Bureau. I apologize. And what do we have left? We have about 4 years of activity on our shoulders with Mr. Artem and with our respective detectives. We are investigating high-profile corruption cases. We have results, but we must understand that the National Corruption Bureau and the Special Anti-Corruption Prosecutor's Office cannot put people in jail, cannot imprison people. because September 5th we established the Anti-Corruption Court of this year, and that is under the jurisdiction of the appropriate court body. What do we have in common with all the work of all the anti-corruption bodies? I have a presentation here. What things do we have in common? Our conceptual model. The idea is that we should counter top corruption, which is much worse for the state than low-level corruption activity. And in Romania and in Ukraine, we encounter political resistance. It's clear for us. We understand the experience in Ukraine. It is hard for us to understand what reluctance and what resistance the Romanian counterpart experienced, but in general the political elites, the oligarchs, are directly trying to sabotage the activity of the anti-corruption body. And there's a lack of clear, quick results. The National Anti-Corruption Bureau is often accused of delivering insufficient results. I would like to give you a comparison. The National Anti-Corruption Directorate has been effective for 17 years, and they've only been effective for the past 6 years. They've only been able to deliver results for the past 6 years. For 11 years, there were no high-profile verdicts. There were no high-profile investigations. We're not trying to say that NABU can do nothing for a long time, but currently NABU is effective, is operating, and the reason in Romania there were no high-profile verdicts, no big fish were fried at the beginning stages of Romania, and the same thing. There's a difference between why there were no high-profile verdicts in Romania and Ukraine. I don't want to talk about Laura Kövesian's predecessors, but I think Laura was more effective. In Ukraine, the lack of effective results, the lack of convictions, is due to the lack of an independent judiciary that is unable to consider the cases in an objective, unbiased manner. Then, with the support of large part of a population and our Western partners, I will go back to this in our conclusions, but again, without the support of civic society, without the support of our Western parties, there would be no case in which the national elites would be interested in the independent functioning of anti-corruption bodies. Politicians don't want anti-corruption investigations because these investigations are aimed against these politicians. The same goes for Romania. And the last common trait is that these are the first bodies in the history of our post-Soviet countries. Don't know if you can call Romania post-Soviet, but it was indeed a communist country. These are the first bodies that started putting up a genuine resistance to corruption. That is what we have in common. About what is different? The director has been working for 17 years, and the Anti-Corruption Bureau has only been operating for 4. In the 17 years, the Anti-Corruption Bureau has referred over 9,000 convictions, and the NABU right now, if you look at our research, our conviction, we have statistics for May. We updated the statistics regularly, and we decided to stop at a deadline. So let's say, because this process otherwise could have gone on indefinitely. So the latest statistics we have for May for the Anti-Corruption Bureau was 215 cases referred to court and 31 convictions. And I'm hoping that by the end of the year, we will have more cases referred to the courts and more convictions. And again, it's a question of whether the criminals will actually see imprisonment. And I think this is a big advantage of the Ukrainian side. We've analyzed positive and negative aspects of the activity of the National Anti-Corruption Directorate and the National Anti-Corruption Bureau, as well as the SAPO. Romania was a bit more controversial in terms of pressure on the court, collaboration with special secret services, the violation of human rights, and the violation of procedural norms. In Ukraine, sometimes NABU's activity can be controversial. In Romania, there's way more controversies associated with the activities of the directorate, and this is noted by many an expert. Our colleagues talked to people in Bucharest, and after which they revised our activity, and this is highlighted constantly in Romania. Ukraine is not, compared to Romania, of course, the problem is much less severe in Ukraine. And last but not least, NABU and SAPO are criticized for being allegedly unable to find common ground. If you actually look at how anti-corruption cases are being investigated, who is overseeing our high-profile experts, of our specialized experts, who are investigating particular nuances in the activity of the SAPO, it is clear that there's something we state in our research and something we mention, the so-called Holodnitsky tapes, or the aquarium, the fish tank of Holodnitsky. We talk about this case. So as a result, our final conclusions, there we go. Having analyzed the above, we think the political situation has a defining influence on the functioning of anti-corruption bodies. If the political elites wish to sabotage the activity of an anti-corruption body that doesn't satisfy their wants and needs, they will sabotage the activity of the body, and they will try to, so to say, behead the body. We have seen attempts to sabotage this activity during the previous government, about initiatives pertaining to parliamentary oversight or to the appointment of auditors for the activity of the NABU. The negative conclusion of the NABU audit can be grounds to fire the head of the OR body. Most politicians express support only verbally and the level of statement, and the same applies to the Ukrainian and the Romanian cases. However, in reality, the politicians have no need for these bodies. Politicians do politics not because they want to change the state, but because they want to profit from the status quo. When high-profile corruption, when political corruption is being investigated, the political elites will try to paralyze the activity of the bodies. And the last thing I would like to stress is, if it weren't for the support of the Western partners of Ukraine and Romania, if it weren't for the support of the expert community and civic society, it would be impossible to overcome, to destroy the hydra of corruption. One thing that I find a bit worrisome is that in Ukraine we don't have that many people rallying to support anti-corruption institutions or anti-corruption movements as they do in Romania. Why? This might simply be a matter of time. Thank you very much. Thank you for listening to my short talk about the anti-corruption reform in Ukraine and the conclusions, the lessons we learned for Ukraine. And now I'm going to give the floor to my colleagues who will have a lot of interesting things to share with you. Thank you, Alexander. I'd like to summarize, and maybe add that our key conclusion is that there is no silver bullet, there is no magic wand, no unique structure that there's no blueprint that could be applied here. The Romanian experience is fascinating. We used it as the basis for our reform in 2014, 2015. At the same time, however, we have a chance to avoid the negative aspects of the DNA, such as when the DNA being criticized for initiating political persecution, for collaborating with the special forces that are exerting pressure on courts, for making unmotivated political decisions. I have spent time talking to various experts in Bucharest, and the lack of trust as a result of this high level of unjust convictions is very much in the air. Sadly, fortunately, in Ukraine, the Anti-Corruption Bureau has a very good reputation. If it continues moving in the direction of establishing rule of law, we will avoid these negative aspects. I would like to ask Mr. Artem a question. I know that the Anti-Corruption Bureau has taken the time to study Romania's experience, has made visits to Romania, and I would like to ask you to what extent do you agree with these conclusions? Has what you see, what you saw, does it correspond with the information in the report? And why did NABU manage successfully, and why will it manage successfully to avoid the Romanian pitfalls? And I hope we will avoid the Romanian pitfalls. The floor is yours. Good morning. I agree with most of the things that have been mentioned in this presentation. However, I would like to say a bit, as the head of a law enforcement body, one of the first experiences we studied when establishing the National Anti-Corruption Bureau was the Romanian experience. I have met Laura multiple times in Romania and in the European Parliament, and we talked. Our offices talked as well, and we had a lot of opportunities to highlight our key differences and similarities. I won't repeat what has already been mentioned. However, one thing that I found pleasantly surprising in Romania is the fact that the Specialized Prosecutor's Office, kind of like a SAPO but in a more extended version, they were able to get support from the police and from the Secret Service, and they collaborated with these bodies. Sadly, in Ukraine, the situation was totally different. We had a very good relationship with the Security Service of Ukraine when it was headed by Mr. Deshina, and the 20,000 employees, personnel of the Security Service. For example, they sabotaged the operation in the Migration Service because representatives of the Security Service took part in this case, and they did everything they could to destroy our department. The same pertains to the police, especially when you look at the infamous backpack case. And I think that the General Prosecutor's Office recently we had the best self-proclaimed prosecutor in the world without a legal background, and we have experienced constant confrontations with the General Prosecutor's Office when we tried to detain Susan, the infamous investigator, and he was in court. Now this case is being heard in court, considered in court, and I think that pertaining to executing the law, for us, following the law was a question of survival, because any violation we made was instantly met with a criminal case. Our agency was persecuted for even the slightest wrongdoing. And the fact that no NABU employee has been convicted, that means that following the law was the only secret to our survival. Our detectives followed that lesson, and I think this is the big lesson for us.
Besides, it's necessary to note that it was an exhaustive list of adverse consequences what's negative about that is 17-year anniversary for DNA, but in the streets of Bucharest you will find the supporters of DNA that aim at raising responsibilities for anti-corruption crimes. Unfortunately, even in 17 years, the society should always protect the independent anti-corruption body. That's what we can track in Ukraine at present. Now, I would like to be frank, saying that comparison before the shift in the governmental machinery and today, the current situation impresses as positive and embeds optimism with us. Such corruption was marked before the Revolution of Dignity, and today we face nearly a similar scenario. This means that the current government needs to overcome the promises of the former government. In December 2018 there was communication to the former president of Ukraine to regulate technical assistance from overseas. We had only one deficiency that needed to be overcome, and I insistently attempted to bring this responsibility under the auspices of president. I didn't receive any answer for 4 years, and eventually the promise was fulfilled after a new president took the office. He unlocked this issue, and now we have found resolution to it. From the point of strengthening the state security service of Ukraine, the law in its new version has been adopted. It is related to top officials, and you might know one of the popular stars in the political arena that is attached to this mechanism. We can follow a few best practices that implies involvement of the deputy minister for the occupied territories of Ukraine, and also regulation of crimes at the level of the Kiev court. Unfortunately, what we traced at this illustration is that the current Ukrainian courts present a unique precedent. And speaking about the higher anti-corruption court, we can track indeed powerful level of cooperation at this point, and we aim at cementing joint cooperation due to numerous efforts that were supported over all the years of our collaboration. Today, political elite intends to maximum assist the current governmentals and all stakeholders in their initiatives. When it goes about the anti-corruption court, I would like to make a note that as of May 2013, the work that was on the way suffered because of hazards and the prosecution. Unfortunately, no real results were achieved, and we didn't achieve any massive support. The reason for that is that our work is never completed to its end. After 1 year of transformations, the society can wait, but now we do recognize that the challenges are high, and the anti-corruption court needs to address this issue appropriately. We cannot wait any longer, in fact. The reasons for that are numerous. When it goes about the law and the regulation of behavior for the political elite, before, for instance, the judge was subject to prosecution. When immediately after suspicion is voiced, and when the resolution of the court is issued, then the administrative sanction is enforced, and actually, when the chamber assumed an, it appeared to cancel such a verdict, and then a new administrative sanction was imposed in the shape of a new regulation that deprived politically engaged judge from his position. Let's take Mr. Martenko's case, where the court issued the resolution to close the case due to signing different rulings of very suspicious nature. Well, we face such a practice where 3 judges intend to make void these resolutions that were issued before, and newcomers that became judges after the former judges left their offices appear to be in rather difficult situations, since they face the conflict with the former government and those in power. Well, normally today, when the police invites a judge or prosecutor to their office for interview, they do not have any security to support them. And I'm indeed delighted that the High Anti-Corruption Court in Ukraine was initiated when a number of new anti-corruption reforms were started. I do entertain the hopes that slightly new approach will be found to the old problems, and legitimate verdicts will be issued, taken that those exposed persons at political level that were found suspicious in their behavior or misconduct will find their landing in legitimate field. And until 2018, when there was another case, and before that moment, the Deputy Minister of Defense of Ukraine was detained. These two cases consequently united all the political elite. The determination was made to dismiss the chair of Nazika, and then the global community opposed to this verdict. As a result, the president of the World Bank and the global community, alongside with the embassies, voiced their pro that helped the former president in December to adopt a new draft law for the new high anti-corruption court that was selected, and it inspired the global community and all the stakeholders to counter all the shows of corruption, and today it inspires us and keeps optimistic. Many thanks, Artem, for your input. At this, I would like to state that at present the High Anti-Corruption Court and the current anti-corruption system that's like cliche that we are normally accustomed to deploying, and the outcome of this system remains unveiled. Speaking about pre-trial investigation, prosecutors' functional and functional of courts as well as that of judges will give us its shows only with time. When we attended Romania, we asked many different questions about the motivation or the reasoning behind the current scenery and the causation for all the processes in place. Well, speaking about Ukraine, I would like to invite Victor to comment here two punishments for the minister and for the oligarchs on their misconduct. We would like to hear your position on whether you agree to our conclusions, but the question will be very simple. Why did Romania succeed? And another ultimate question, why did the courts approve the resolutions? Why did not they suspend the case settlement? Why did you receive these accusatory verdicts? Since these highlights are indeed critical for Ukraine at present, at the moment of shaping high anti-corruption court, since we're interested in securing adequacy of these materials that will be topical for this inspection and for this initiative. Victor, many thanks for your upcoming input. For those who need headphones, you're more than welcome. Please take them from the desk at end.
Thank you. First of all, before jumping into these very interesting topics, I would like to thank the organizers for this great opportunity to be here and to share in a kind of balanced way the Romanian story, and mostly in order to inspire drawing lessons and trying to maximize good examples in transfer of best practices, and also to avoid what others already did experience and saw that might be gaps and vulnerabilities. Even though I'm a member of High Judicial Council in Romania, and I'm also leading the global program on judiciary of Transparency International, I will sit now from the perspective of fight against corruption and what TI Romania is seeing as priority. Transparency International overall has two main ways to promote and to assess the success of fight against corruption in our countries. One is effectiveness, so it's important not only to have actions, but it's very important to have a deterrent effect in society. And secondly, sustainability, because if we have a wave when we have a good image of something is going on, but later on the payback it's coming, that will end up with lack of trust from society, lack of trust from legal professions, and mostly lack of trust from investment environment. In Romania, DNA was created, including with the support of Transparency International Romania in the very early stages, because there were 3 stages, PNA, Anti-Corruption Prosecution Office, and then this current setup was created for 3 reasons. One, to have punchy capacity of state to deal with white criminality, very complex white criminality. And in this respect, it's important to have specialized investigative bodies and specialized units to deal with, because they will increase constantly their capacity, their know-how as the criminality is in evolution. Second reason was to create more independence of those prosecutors from many other priorities might have the General Prosecution Office, because they have to deal also with organized crime, with murders, with rapes, with broken houses and so on. Also, crime is very dangerous for our societies and for our citizens. Somehow we need to put clear emphasis, clear budget, clear infrastructure in hands of this narrow priority, but very important one. And third reason for the current setup was to put all resources on one basket, and therefore National Anti-Corruption Directorate in Romania, which is a specialized prosecution office, benefit by its own judicial police and its own experts in such a way to deal in a very confidential manner with all aspects of the case. Of course, that's subject to be reviewed later on by courts, by judges, and it's subject to be challenged later on by the defendant and its lawyers. But at the very early stage, it's important for them to have full investigative and operational capacity to deal in a confidential and quick manner with this subject. And now when it's coming about timing, because the director of the of NABU says people are not patient with corruption. That's true, and they should not be. But on the other hand, when we are talking about white criminality, we need to have diligent investigation. We need to have due process standard in such a way those cases to be sustainable in front of courts. Sometimes it's taking more time to do it. You know, it is clear notion that justice delay is justice deny, but also fast food justice is not justice. So we need to be balanced when we are setting up our own expectations. The whole concept of fight against corruption, it's not related only to criminal side, it's also related to preventive and administrative side. One mistake we did in Romania was to put so much emphasis on criminal law as a remedy against corruption, and we forgot about the rest of instruments. And you need to not only to put behind bars high level corrupt, but also to reduce the fog in society, the endemic corruption itself, which later on will also help the criminal justice side. And it's important to have independent judiciary. Because we had experience when prosecution goes against judges, which were in charge with ruling cases submitted by the respective prosecution offices, creating vulnerability for judge, some of them being suspended during the criminal investigation, even though in the end either the prosecution withdrew the case, either the court dismissed completely the case with full acquittal. And we tried to understand what is happening, and actually it's kind of institutional or a systemic conflict of interest. if we are having equality of parties in front of courts, it's quite unjustified that the prosecutor, which is submitting the case, to have means to turn against judge later on different grounds. Some of them potentially created, some of them partially real, and the defendant not to have that. So therefore we create a special investigative unit which is dealing with crimes committed by all magistrates, meaning prosecutors and judges, and this unit is not entitled to go in front of courts to represent their cases. They are doing only the investigation, and the representation is done by judicial prosecutors, which are kind of lawyers in front of court from the prosecution side, to defend these cases. So it might be tricky if, for example, now, you know, in very beginning stages of reforms, it's lots of love. Later on, are many arguments and subjects to have, let's say, misunderstandings. It is important not to have means to go against judges. That happens in Romania, and therefore Constitutional Court came with few Constitutional Court decisions which actually affect strongly the sustainability of fight against corruption, because the means and ways to do it were not necessarily very proper. So the independent judiciary, independent courts, it's key. So courts which are ruling upon those cases needs to be fully protected by any political interference, but also by any interference coming from the parties, including the prosecution side. And this is with figures, with facts, it's clear lessons drawn for us. For example, the current president of Supreme Court, in Romania the Supreme Court, it's, the name is High Court of Justice and Cassation. She was subject of criminal investigation started by prosecutors, along with president of section of administrative dispute section and president of criminal section of the High Court, and after 4 years they have been completely found innocent by both level of jurisdictions, meaning 8 judges from High Court of Justice and Cassation. And now she, after she passed an exam, became president of High Court of Justice and Cassation in Romania. So we have examples. We need to look into preventing, to repeat some gaps and mistakes, to rebalance, because people will believe in fight against corruption if an independent court will do that. And therefore courts should not provide verdicts because the public emotions or because the politicians. Secondly, was mentioned that usually the politicians do not want anti-corruption. Partially is true, partially is not. Are some politicians which are really committed to do that, and we have some examples in Romania of politicians which did that, mostly in their capacity, meaning administrative intervention, and they change procedures, for example, licenses for houses, licenses for cars, obtaining paper documents, identity documents, and so on. Very electronic, very fast, very randomly, and objective procedures which actually diminish a lot petty corruption. And we have other examples too. Those politicians have been elected as mayors again and again and again. When a politician is saying, I'm committed to fight against corruption and to ensure law enforcement, and I committed to support judges or courts, I start to have some doubts. Of course, it's necessary to have political will, but to set laws, not to support judges. If you have means to support them, you have means to incommodate them too. It's a two-way street once you open this channel. So it's important for them to set out appropriate laws through legislative function, which is political function in any democratic society. But it's debatable if a politician has ways to, let's say, provide support to a court or to an independent prosecutor. It is not clear-cut also related to who is against the fight against corruption, not only politicians, but also very important business actors. Because most of the time fight against the corruption and fight against corruption will meet also crimes like fiscal fraud, like money laundering, and so on. And this is related to very powerful actors. And they have media capacity as well as oligarchs has. Another thing, it's related to balanced priorities. In the Romanian case, what was a success was the priorities have been set for high-level officials and crimes with very significant impact, meaning amount, as it is in Ukrainian case, or meaning the personal capacity, but not only in the public sector, but also in the private sector. Because, you know, corruption is like a tango, it's played in two. Some key lessons learned from our experience. It is important to avoid instrumentalization of fight against corruption, because we'll end up with no trust from society if the fight against corruption becomes a message associated with one side of political spectrum, meaning left or right, I don't know the specific situation. Then it's like football teams' fan clubs. You will believe that your team is disadvantaged by the referee. You lose your trust, and it's important to have trust in those institutions. And those campaigns with politicians supporting the fight against corruption, comparing with others which are not supporting, will lead sooner or later, and that happens not only in Romania, but in many other countries, Transparency International noticed, to selective justice. It's highly important to avoid, under any circumstances, selective justice, meaning white lists, cases which are kind of cover-ups, and cases which are forced, even though are not with solid basis. It is very important to have an objective approach and to have unified judicial practice, to have constant judicial practice, either in prosecutorial phase, either in adjudication phase. Last point, because I'm running out of time, is related to another risk. It is a benefit to have anti-corruption heroes. It is a benefit to have anti-corruption champions. It's useful for mobilizing people. On the other hand, the second part of the same coin, personalization of institutions, it's huge risk, because then you put the entire emphasis in persons and not in mechanisms, not in administrative capacity, institutional effectiveness, and so on. So criteria to assess should be objective ones, and those heroes, they are heroes because they are good professionals, not because they are kind of pop stars, because everything which is related to judicial functions should not be in any way overlapping with that approach of pop stars in media. This is a trap, and sooner or later the payback is coming. Thank you.
I would like to continue saying that the Higher Anti-Corruption Court does not put criminals behind bars, but what they do is carry out due justice for categories of cases with certain amounts of damage or certain subjects. If, as a result of this due justice, a criminal is indeed put behind bars, this will only be a result of justice being done. There could be, but the consequences could be opposite, and we understand that we're all trying to establish a state with rule of law. We're trying to implement the key principles of rule of law in Ukraine, and if the result is contrary to our expectations, that does not mean that the case did not lead to any result. This means that during the pre-trial investigation there were issues in the procedure, or maybe there is a lack of evidence, or perhaps there were other circumstances that came into play during the criminal violation. And this is also a result, because I cannot comment on other cases, but if you look at the decisions that the verdicts society is unhappy with, these verdicts also lead to the establishment of a just pre-trial investigation procedure. Because the work of the pre-trial investigation is extremely difficult to investigate these categories of crimes. First of all, these are usually crimes of economic nature. When there's murder, it's clear. There's murder, there's a DNA, there's forensics, there's DNA, everything is very clear. But when the crime is economic, when you've got to follow the money and see where the money originates and where it's headed, where the money was laundered, and it's hard to follow the money. Number one. Number two, going back to the verdicts that were mentioned by you, such verdicts are still a result, because lessons will be learned. The judiciary system is the final beneficiary of pretrial investigation. It is the judiciary that is tasked with making an objective verdict and giving the motivation of why certain types of evidence cannot be accepted by court, and this motivation should be taken account by the pretrial investigation body to avoid these mistakes in the future. Number one. Number two, and I'd like to maybe go back to my previous experience as a lawyer, but I think I'm going to say that the NABU detectives, they are doing a colossal amount of work. We've been collaborating since September 5th. Every day, the investigators and the judges get at least 50 applications from NABU, 50 petitions from NABU detectives, and this is a colossal indicators. Of course, the results of this investigation can be different. They could be partially met, or sometimes they are refused. But compared to other pretrial investigation bodies, I think the quality here is so much higher. Of course, if there's issues, then makes no point talking about satisfying these petitions. If there is no question of the investigating judge, that means that work is being done in this area, and we only have to see how it's going to go in the future. But at this stage, sometimes we feel that the NABU was waiting for the High Anti-Corruption Court to come into effect to flood us with documents, with procedural documents. We are getting a lot of information on requests for temporal access and arrest of assets and sanctioning of their investigative activities, and requests to get acquainted with pretrial investigation materials. So all of the aspects of the pretrial investigations, they make it to our body, except for search warrants, because right now we do not have the jurisdiction to consider search warrants. So there's a lot of work done in this sphere, and we can feel it every day personally. Thank you, Ms. Vera. I have another question. Talking about the Romanian experience, we've already talked about NABU and the quality of the cases and the materials that make it to court. On the other hand, everyone is concerned with the issue of the independence of the High Anti-Corruption Court judges. How is this independence guaranteed? And you, as a judge, how do you feel? Are you able to be independent? Because you are looking at very high-profile cases, because we hear a lot of political statements from the president, from the numerous politicians. We hear there's a high demand for justice in society, and the question is, can you actually maintain due process of law? do you have the strength to do this? And is there anything you're maybe afraid of professionally? First of all, I would like to again to tell you what selection criteria they were when we were during the competition for the High Supreme Court, for the High Court of Anti-Corruption judges. Regarding the pressure on judges, we've been working for 3 weeks, and in these 3 weeks we haven't had a single case of the judges' activity of interventions into the activities of the judges, or any attempt to intervene into the activity of the judges. What scares me is the constant reminder that criminals should be behind bars, behind bars, behind bars. We feel pressure from this angle because the judges of the High Anti-Corruption Court were selected to do judges as per the requirements of the Criminal Procedural Code. And the Ukrainian high-profile officials, the politicians, it's their mantra. They keep talking about incarceration, and I think that for society, for the layperson, this is a message that needs to be followed through to the end. I think we could consider this type of messaging as pressure, because if we want is due process, we should expect due process towards everyone. Otherwise, we encounter a situation regarding double standards. If we've got a district court in Kiev and they are considering a case with my neighbor as a defendant, I want this to be fair. But when it's the High Anti-Corruption Court and they, using the same principles, the same basis, the same criminal procedure of the CPC, if they are considering hearing a case about a high-profile official or a case involving high-profile corruption, we call for instant incarceration. And I think these double standards are a cause for concern. We think this tendency is very dangerous when trying to establish a state with rule of law. We have recently made a visit to Singapore on a session dedicated to rule of law, and if you compare Ukraine and Singapore, then the system in Singapore, you can be critical of the system, but if this is the system the people have chosen, this is their choice, it's a choice that we must respect. However, we understand that control, this excess control of everyone, all parties by all parties, is the result of a society that was blood hungry, a society that wanted to put criminals behind bars at any cost, regardless of the preservation of democratic standards and rules and principles. That is very dangerous. Thank you. We've talked about Romania and Singapore. This is a classic set, the sort of starter pack of foreign experience that people reference when talking about anti-corruption. And of course, it's extremely important to talk about risks without idealizing the experience abroad. The Ukrainian justice system also allows activists to protest courts, and in Europe this would be considered pressure against the court, something unimaginable in EU countries. That is why maybe Alexander and I need to apologize for using the word bars twice in this discussion, but I think that's the tone our president is setting. Before we move on to our Q&A, I would like to ask our esteemed panelists if they have any questions to ask each other, because Mr. Victor, it's a rare occasion for Mr. Victor to visit Ukraine. I don't think we see each other every day either, so maybe now would be a good opportunity to discuss these things since we're all here. Any questions we'd like to ask each other? I don't have any questions, because I'd like to avoid accusations of pressuring the court. It brings me great pleasure to listen to the high quality of the policy of this review, because it's very hard to work with quality. 4 years, we didn't have a single day to relax. We have 10-15 lawyers per case that are paid, and they're trying to sing for their supper, so they do everything they can in their cases. For me, this word bars, putting criminals behind bars, something I've been hearing for 4 years. And I think you could perceive this as pressure against anti-corruption authority, pressuring. But I think the fact that we keep hearing this mantra is that what society wants isn't verdicts. We want verdicts. We want just verdicts. But society wants justice as such. And when society sees that there are open processes and money is being laundered out of this public sector, money is being laundered out of the budget, and the judges of regular courts own 10 apartments, 10 cars, and the same pertains to prosecutors, then society loses a feeling of justice. This loss of feeling of justice was what led the people to the Maidan when they wanted to oppose corruption. They wanted corrupt officials to be behind bars. I don't think we should perceive this as pressure, but instead we should see this as societal demand, a demand that must be met, of course, under the auspices of the law. And when we hear activists protesting courts, I'd like to remind you of an experience from our case, and there are people who took part in these events here in the room. We took the ex-head of the fiscal service was brought to the Saloninsky district court. It's a very old story, and the judges failed to show up to work. And what should society do in this scenario? I start calling the heads of the judges, of the courts. I don't ask them to make a verdict about arresting or about imposing a bail. All I'm saying is that basically you're self-abdicating from performing your duties, and here the people appeal to the Constitution, because we the people are the source of power in Ukraine, and the people come to protest the court. The courts aren't in office, and we see processes that could be classified as pressure, but I think you need to understand people who are working in law enforcement, who are working in the public sector, who are working in the judiciary, we, the officials, it's our fault, it's the officials' fault that society, when the state self-abdicates from executing their functions, society takes power into their own hands. We need to understand this, and we need to work in such a manner so as to, on the one hand, society gets what it demands from society. On the other hand, we should also maintain rule of law and maintain due procedural justice. It's extremely difficult, but this is a challenge that we are facing, that the NABU is facing, that the SAPO is facing, the Anti-Corruption Court is facing as well.
Many thanks, Mr. Artemov. The Ukrainian society is indeed very vulnerable to the issues that you mentioned. Another thing that I would like to comment on, it is about unbiased political decisions. Let's label them this way. Speaking about my arguments towards you, Poles, I would like to say that before we used to suffer from the remnants of the past on that day, I would like to call on all the judges to arrive to their jobs not only for the sake of salaries, but settlement of taxes and, well, joy after all. Speaking about protection and defense of employees at NABU, we normally receive claims not only from NABU but from law enforcement bodies as well. The claims of both types are normally scrutinized with equal level of legal scrutiny and attention, concentration that is attached to high level of competition. Another argument that I would like to support with this, that Artem voiced a few moments ago, is that there is a schedule set out for us, and each second weekend we have a judge on duty to address. For instance, when the entire nation has some holidays, national holidays, irrespective of a day of the week, we have a judge on duty. This means that the schedule of services on duty are set up and they help to service of the general public. Actually, the judges before started in depth of the regulations, and I do entertain the hopes that the transformations in the higher anti-corruption court will be in place. At the session that we had today, we had a very vivid discussion to be able to showcase these challenges that they face and set out the problems to resolve for the future. Questions from the conference room. Hello, I'm Volodymyr Chekhovsky, NGO Chestna Ukraina, that is translated as Honest Ukraine. I would like to address those who represent anti-corruption bodies of Ukraine. I have got two brief questions. If possible, please take your time to be able to give me an exhaustive commentary to that. Do you need a competitive salary to be able to secure your family and cater to their needs, despite that there might be some potential financial leverage or some hazard of bribes or suggestions of crime or misconduct to be able to survive in the current reality? And the second question is whether there is a need to raise the ceiling that we face at present. And most probably the third issue will be about delegation of powers, where some germ will be delegated, for instance, to return the assets that were embezzled. 100 billion Ukrainian hryvnia were withdrawn from Ukraine, or some slightly minor amounts were withdrawn overseas. What is to be done to return these assets that were withdrawn? On my part, I would like to state that salary that I receive what's the fifth? Well, it does not liquidate any corruption risk, but it diminishes this risk at large. My current salary is competitive against the European level. This means that my salary is not an acute problem at present. My ultimate mandate is to align the current anti-corruption practices and procedures in place with these processes that are on the way in Ukraine. From the point of salaries and NABU's input, it will be the government of Ukraine that will decide the limits for salaries. Again, the ultimate mandate of NABU is to conduct investigations, but the government cannot exercise its impact on that. But again, I would like to say that votes cast in favor of amendments that ought to be entered into the pertinent legislation, they will be an answer to a question. From the point of amount of your salary, I do not think that the amount is an issue. It will be salary that you receive systematically that will respond to the issues that you raise. Speaking about the picture overseas, quite often we speak about the verdicts and these authorized employees or persons, let's say some homeless, that will be found accused and then found guilty. He will be put into jail, and we can impose any court injunction on such a homeless person. This is a possible practice, but yet it appears to be slightly unrealistic. Speaking about Ukrainian realia and all the scenarios that are in place and beyond its boundaries, I would like to say that these assets that are withdrawn abroad and where the regulations governing preserving assets are indeed a key to finding solutions to the topical problems that the current society meets. And another thing is that we had some specific national element that governed the current realia. For instance, we had Lutsenko that participated in a sit-in, and then we found sort of lockout for the case. In Romania, the pictures are identical. Well, for instance, when some top official participates in a case, it looks like lockout. like a blockade for the furtherance of such a case. In Ukraine, unfortunately, we cannot give any comment on that, any comments on that, and from the point of attempts of the Turkish side undertaken to regulate the current schemes, I would like to state that being governed by the rule of law and fair justice, it's not sufficient to set out a line of current laws that will resolve the problems in place. From the point of power abuse for the court, that is a direct pathway to the EU Court of Justice, where the case will be settled. Speaking about happy salaries, a person is happy when he or she gets not that much, but when they find their salary sufficient. Most probably this is because we're rather mature grown-ups, having sufficient experience behind us. And at this, I would like to state that in Ukraine and at the state service, I do not receive lower salaries than I used to receive while I was working for the private sector. Now, I would like to maintain that all of my colleagues normally support my pose, and whenever it goes about corruption factors, agents, or some financial leverage, or a sort of bribes that are demanded, I would like to state that the hazards of confiscation always appear risky, and it's a dominant power of a detective and prosecutor as well to conduct investigation in this regard. So far we have a sort of weird canvas of what is going on. It's a pale picture. It's not a pretty well articulated roadmap yet. Hello, I'm Victor. I represent the Anti-Corruption Initiative in Ukraine. Many thanks for an opportunity to report at the conference. And at this, I would like to welcome all the representatives that participate in the current forum. First, I would like to address Victor and Vera to give their inputs. Victor and Vera, please comment about the past practices of the Soviet Union, where planning was a major part of national economy. But in Ukraine today, the general public lives in such a reality that lags behind this reality in the third countries, not even other emerging countries, but the third world, like Africa, for instance. Speaking about Ukraine, I would like to call on all the top officials and representatives of the governmental machinery that are with us. I would like to state that before we focused on searching investors of our state, those that donate money to the accounts, among top priorities to be resolved, I would like to state that the prosecutor's office, alongside with the police, should be scrutinized from a different perspective. The courts today are not selected by the citizens of Ukraine, but they do deserve proper attention. The judges and their appointments present risk of bribes. This is top hazard. The second is voting for bills. Quite often MPs are not available at meeting of Verkhovna Rada of Ukraine, and in the parliament we see how buttons are hit without physical presence of MPs. This means that the laws are being adopted without physical intervention on representatives of the general public. We have pertinent law to condemn such practice. Article 42 of the Constitution provides clear reply to this problem. whenever there is a court injunction on the punishment that is to be imposed on the perpetrator, then there should be alignment of powers and punishments, and the regulators' powers should be assessed and aligned with the subjects that fall into the competence of the pertinent punishments. At this, I would like to request whether there is a system of judges, starting with the Supreme Court of Ukraine, whether there is some responsibility of MPs for falsifying the bills. And then, Vera, I would like to call on responsibility for misconduct and rule of law. The rule of law will govern, and the state will need to scheme the values that are top priority in Ukraine. And this, I would like to state that Ukraine is for not the poorest country today, and expectation of very critical workload is ahead of us. Nabu, Nazika, and SBS cannot go to the High Anti-Corruption Court just out of a sudden, go to these institutions with a claim of power abuse. Speaking about Romanian experience, I would like to explore whether the Romanian institutions face proper mechanisms to govern combating power abuse. I would like to call on Vera and Victor to reply briefly to my comments. Vera, I would like to state that in response to the powers of High Anti-Corruption Court, we normally hire common people. In line with the procedural code of Ukraine, the High Anti-Corruption Court appears to be the top-level institution in this respect. It does not enter any entries into the registry of anti-corruption proceedings. Speaking about responsibilities and imposing punishments for the breach of the pertinent legislation, as well as in terms of conducting investigation and entering proper data into the registration of investigations aimed at preventing corruption, including involvement of civic society, NGOs, self-regulated organizations, where the claimant address pertinent institutions with a number of different claims, and following Article 310 of the Procedural Code of Ukraine, such a person can go to NABU in case when gets about direct accountability of his case to the court of first instance, for instance. This means that today we face authorization of the courts that can make it bound for a detective to track the process and enter pertinent data into the registry, and then to start investigation in case when proper foregrounding is in place. But in case when there will be no response when the claim is submitted, then you should go to the High Anti-Corruption Court to determine the level of accountability of courts and jurisdiction eventually.
It is important not only to emphasize the work of anti-corruption prosecution units and specialized courts, but also some complementary authorities like authority dealing with prevention of money laundering and collecting data. Also needs to be established a contact point and effective mechanism for cooperation with other legal jurisdictions in terms of detecting, freezing, and if it's the case, recover the stolen assets, which are in other jurisdictions than Ukraine, because this is a call that Transparency International made also at G20, now to the European Commission, and also at the Anti-Corruption Summit in London. And majority of governments took into consideration this as a priority, as we are calling follow the money and recover them. So are many other institutions than the classical ones we know. Actually, we have to look into the whole ecosystem of instruments and tools, legal tools, available to sort out this. What you can do as civil society in this respect, for example, to hold for full accountability in terms of effectiveness of investigations, meaning what amount of stolen money have been frozen, how much from this have been proven as being produce of crime and have been confiscated. So somehow it's not necessary only to have sanctions against persons, but also remedies to the produce of corruption. In Romania, I'm not going to reply to the Ukrainian situation, but I will tell you how it is in Romania. For example, if a judge is doing a disciplinary misconduct, then it's Superior Council of Magistracy, us, which are dealing with disciplinary measures against them. If it's a criminal charge, it's a regular criminal charge, of course with some special procedures, because it needs to be protected the independence of justice in principle. Related to transparency of decision making and forgery, you mentioned something about forgery of votes in the House. Then in the parliament, then it's a regular crime. But look at the recommendations Transparency International Ukraine made in their program proposed, and you will see the strong chapter related to transparency of decision-making process and inclusive decision-making process in order to ensure democratic standards and integrity. And then you might try to find ways to pick this battle.
Many thanks for your input. I believe that we are short of time. Well, a brief commentary. Because of that's MP of the local court. When we tracked that there was a sort of exhaustion on the part of the general public for the fair justice, we appeared to agree with Mr. Sutton's position, where the general public started riots, and for the past 5 years the general public has been waiting for the fair justice to arrive. Experienced attorneys, judges and courts kept up attempting to prove that Martin, Konoserov, Aksenov and everything was subject to rule of law, but we would like to receive responses that will comply with the principle of rule of law. And at this, we do have hopes that we will be secured against corruption. Many thanks for your commentary. At this, I would like to add the final touch to the current program, and my ultimate mandate at this to extend my gratitude to the speakers of the two invited. Artem Sitnik, representative of NABU, chair of NABU. Next to Artem we have Victor, that's representative of the Romanian Transparency International. Vera and Alexander, representatives of anti-corruption initiatives. Alexander being founder of NGO for Anti-Corruption Initiative, and Vera, representative of governmental machinery.